All right, we are on the record next here for the 28th Circuit Court for Wexford County's case of People of the State of Michigan versus Amber Michelle Nolf. This is case number 24-13951 FC. Appearances, please begin with the Assistant AG.
Good morning, Your Honor. Michael Doby for the people.
Robert Hartel from Ms. Nolf, who joins me at the table, Your Honor.
All right, thank you. We are here today for a sentencing in this case. It involves two convictions based upon the entrance of a no contest plea as to two counts. Count one was concealing the death of an individual as a second habitual felony offender. And the second offense was delivery of a controlled substance causing death. Did we get rid of the causing death? We did. But it was delivery of a controlled substance as a habitual offender second. All right. Let's take a look here at the pre-sentence investigation report. Mr. Dolby, do you have any amendments, corrections, or objections to make, sir?
Your Honor, I just want to confirm that the court received a copy of the victim impact statement. The family.
I did. I did receive that. I think via email with permission from Ms. Frick, who is the victim witness coordinator for the prosecutor's office here in Wexford. And Mr. Hartel, did you all receive a copy? I thought I saw you on the email.
Yes, I received it and I discussed it with my client.
All right, great. Thank you. So the answer is just yes, I did. Let me just check. I know that you're not here in the courtroom, by the way. Mr. Dolby appears via Zoom. He's an assistant attorney general. Ms. Frick, I don't see any of the victim's family members here. They're not here, and you don't expect them to appear via Zoom.
They're not coming.
Okay, thank you. All right, Mr. Dolby, anything further?
No, thank you, Your Honor.
All right, Mr. Hartel, any amendments, corrections, or objections to be made to the contents of the pre-sentence investigation report?
No, Your Honor.
All right, thank you. Mr. Hartel, allocution.
Thank you, Your Honor. Anytime there's a no contest, especially for civil liability, I'm a bit overly cautious to say too much about the underlying case. But what I will say is that I am proud of my client for what's occurred recently. She's been working with my office social worker, Mr. Brian Henniger. She has every desire for, when she is released, we realize that's almost certainly not going to be today, but when she is released, she does want to get into sober living. She does want to overcome some of the issues that she knows is a reason behind many of her convictions. In fact, we are consciously aware of the fact that she did receive a bond violation in this file due to those addictions. It's something that she's had time to think about for quite some time now, and she definitely doesn't want to see herself continuing to get back in these situations. And again, without going too much about the underlying case, she does miss her friend, and it's unfortunate that I know she's not the only one who's never going to see him again, and I'm in no way trying to take away from his family, but she is consciously aware of that, and that is something she has to live with for the remainder of her life as well. I would ask the court to factor in that even though she didn't have much credit on this file, she has been incarcerated for a decent chunk of time, minus the small amount of time bonded out. I want to say around a year. One of the reasons I bring that up is I know that post-arraignment, while serving a sentence, they don't get credit, but they're still in the jail. And even before that, when she was sitting time on other things, even before being arraigned on this, it was after the incident date involved. I'm not going to say that the state should have brought the charges sooner. I'm just asking the court to factor in that it's been a long time since she's had a decent chunk of time that wasn't incarcerated. I did read the victim's letter. I discussed it with my clients. I do thank the family for submitting it to the AG and the AG submitting it or through the proper channels, victims advocate, etc. I do think it was well written. I do realize the court's going to factor that in, but it's not the only thing the court will factor in. One thing I noticed in it, not only that they're asking for her not to be released today, which we're realistic about those odds, is the way I interpreted the letter is they're asking the court to maintain the Killebrew agreement. I'd ask the court also to maintain the Killebrew agreement. I don't think my client's going to wish to say anything due to the fact this was a no contest, but I thank the court for its time. Thank you.
Thank you. Mr. Dolby?
Thank you,
Yeah.
Your Honor. I do ask the court to sentence this defendant in accordance with the recommendation. I am asking for the 28 months on the minimum. A prison sentence is certainly warranted in this case, taking into account some of those things that Mr. Hartel said, including the time in jail that she's not strictly entitled to credit for. I believe that is a fair sentence based on the facts here.
Ms. Knopf, you have the right to make a statement if you choose to do so. However, as Mr. Hartel has already noted, and I acknowledge as well, there's been a no contest plea. Therefore, it's not, it's relatively uncommon for people to make a statement. I understand that, but I still need to allow you the opportunity. Is there anything you wish to say at this time? Well, I'm going to go over this. There's a lot to say here. I'm going to caution, and I'm going to make a statement anytime I ever see this. And I understand counsel are doing the best they can in submitting a mitigation report. On page 2, it says, quote, Ms. Knopf expresses full responsibility of her actions. Don't ever do that again. She didn't express anything for her responsibility, and that's okay. But don't tell me she expresses anything. If you want to do that, then the person needs to enter a plea. Something else. Or I'm sorry, as a guilty plea. I'm not going to accept a express full responsibility statement ever again in any. I'll just call you out every single time. Don't do it because she doesn't. All right. So the defendant is 38 years of age and she has 6 children. She has an extensive prior criminal history, and therefore that means that she knows the responsibilities. She's 38 and she's ignoring her responsibilities. I appreciate that she has got some kind of some certificates here. Well, let's cut right to the chase on this file. On Sunday, the defendant was found dead in his vehicle out on 29 Road, out west of Cadillac. 29 Road comes off of M55 and shoots off, or this instance was out south of that road, and he was found dead. And I'll note here that Ms. Knopf contacted, according to the reports, and the preliminary exam contacted the defendant's wife because they've been looking for the victim, Pat, and contacted his wife, Sherry, and he even had the gall to say, "Did you ever find Pat?" quote unquote. All the time, she knew exactly where he was. Mr. Johnson had last seen on Thursday. He was found dead on Sunday in a vehicle out in the middle of nowhere. The wife, Sherry, and the son, Ethan, were trying to find the defendant. He didn't come home. They're looking for him throughout the weekend. And Ms. Knopf knew exactly where he was because she was, quote unquote, his driver. Sherry told Ethan that when Pat was found dead in his vehicle, and Ethan rushed out to the scene to help identify his father's body. Now, I'll note here something about some eviction of Amber and Mr. Ford, the other person she was with. But anyways, this case all boils down to page 33 of the preliminary exam transcript, beginning at line 8. And the question was asked of the witness, Miss Libby, who I know from previous cases, quote, she had shot him up one time and said he had like set back but wanted more, period. She said he told her that wasn't enough, period. So clearly, Mr. Johnson had a severe issue with controlled substances. She shot him up the second time and he fell away and he fell forward like, I don't know, but then it ended. Then it continues on again on line 14. Quote, but she did say she shot him up. End quote. So, kind of a sword issue here. Mr. Johnson decided to go out with his driver out into the middle of the rural part of, I think that's probably Cherry Grove Township, and shoot up controlled substances. She left him there. She called her friends. They came and picked her up. She was in a panic, hiding in a ravine alongside a road. They wanted to call police and get him help or get somebody out there. She refused. Don't do it. She fought. Don't do it, because it would be incriminating for her. And this went on for quite a while. So now I've got to find, well, I don't really have to, because the guidelines are not mandatory. But if you were to look at this agreement, the agreement is to have a minimum jail sentence or prison sentence of 24 months. But yet the guideline range is 38 to 95 months for a second count. Now, there clearly are not anything such as compelling, substantial reasons to deviate from those guidelines. She went out. She's been a drug user. She's had lots of experience with controlled substances, including methamphetamine, opiates, prescription drugs, and others. Quite a long time. And the victim died from a combination of fentanyl and methamphetamine. By the way, when she left the defendant there dead in his car or his truck, she took his wallet, took his keys, took his phone. I wonder what was on the phone. I don't know, but I'll leave it alone. All right, so if we take a look here at the defendant's prior criminal history, which is getting to be extensive, beginning in 2006, I see a lot of crimes, school drug cases. I see multiple probation violations, discharge from probation unsuccessfully. I see a lot of offenses. For instance, if I go from entry 3 to 4 of 14, she made it 2 months back in 2009 before getting picked up while on probation for another charge. Then between 4 and 5, she made it not even a year. She made it 9 months, and she was still on probation, multiple probation violations. Between 5 and 6, she did make it a year, and but it looks like she still owes money on possibly that file for fines and costs. And so when somebody tells me she's been working for a long time at West Shore LLC, I suspect that she just chooses not to pay. Anyways, as we continue to look down her criminal history in entry 6 of 14, she's got probation violations. Entry 7 of 14 committed while on probation. And by the way, she was also on, it looks like she was on bond for another retail fraud, and she made it 4 days before not only violating probation, but also violating bond. And in that other case, number 8 of 14, she had multiple probation violations. Number 9 of 14 occurred while on bond, and yet she had multiple probation violations. 10 of 14 occurred while on probation. And then it continues. Number 12 of 14, which is this file, and our 2 cases here. Wait, at least 2 separate cases. One moment. So, yeah, so the death occurred back in 2023. Is that right, Mr. Potter? I think so.
Yes.
And then she got picked up for the methamphetamine charge. Then she got picked up for a methamphetamine charge. She got a plea. Looks like she just got some jail, so she picked up that while the charge was waiting. So I have no idea. Hold on. When a case comes to the court, there is very few opportunities for the court to exercise its discretion. The court makes rulings, of course, within its discretion on legal questions presented. But when it comes to the value of the case, it doesn't come before my discretion until I get to sentencing. There's no way I'm going to follow this deal. So, we have a significant drug problem in this county, across the state, across the country, but particularly here, I'm concerned about Wexford and Missaukee County. And while obviously the victim here was quite involved in controlled substances, I know the victim. I'd had him recently in a drinking and driving, I think maybe a couple years ago. While yeah, that's part of that person's problem, this defendant dealt him drugs and injected them into him so he could die. Heck no. Somebody thinks that a death of another individual was worth 2 years. No. You have right here an admission from the defendant to another witness. I shot him up one time. He said he had like setback but wanted more. So I gave him more. Good job. And you left him out there. Horrible conduct. Horrible. And this mitigation report, I appreciate the attorney's trying. She got 6 children, but she's ignoring them. She had a job for a while, hasn't paid her fines and costs in some of her other files. She's been to rehab, has quit some of these drugs. Great. She does not express responsibility, which is, of course, her choice. This did not help her. She's out there giving drugs to somebody and then causing them to die, and then covering up the best that she can by stealing, taking his phone, taking his wallet, taking his keys, and calling for help and saying, don't. So, guarantee that you're going to have a moment here in just a minute to choose to withdraw your plea, because there was a Killebrew agreement. However, and before I get to that point, this court is going to establish what it believes this case is worth based upon all the factors that I've discussed. For count 1, the concealing the body, the court exercises its authority to sentence the defendant as a second habitual felony offender. The court sentences the defendant to a period of 28 to 90 months, and the court gives the defendant 142 days of credit. Court assesses a $68 state minimum fee times 2, because it brought 2 felonies, $130 crime victims' right fund fee, and I'm not going to assess any other costs. As to the delivery of the controlled substance, which we know, according to offense variable number 3, scoring 100 points resulted in the death of another individual. Court sentences the defendant to as a second habitual felony offender to a period of 95 to 360 months with 142 days of credit. Again, I've already covered the $68 state minimum fee. One moment. I find that this sentence is reasonable and proportionate based upon, again, all the factors that I've discussed. Repetitive probation violations, bond violations, she's not supervisable. This caused somebody's death because she decides to spend her time in the drug world. No, she's going to go to prison. Now, based upon the pre-trial agreement in this case, the defendant has a Killebrew agreement, and she has the right to withdraw her plea and have this case set back for a final pre-trial conference. Mr. Hartel, is that what your client wishes to do?
She's advised me, yes, sir.
All right, she will withdraw the plea. The court must grant it pursuant to the law. Pursuant to the pretrial agreement, this case will immediately be reset back on the court's final pretrial conference docket as soon as possible and will be scheduled for trial, and it will take precedence against any other trial. Thank you all very much. We are adjourned.
Your Honor, since this meeting's been reset for pre-trial, could we address bond? I believe she.
No, she's not going anywhere, Mr. Hartel.
Understood.